Hi everyone, welcome to That Depends podcast. I am Resham and I'm as usual joined with my co-host Vasudev. Today we have a special guest with us, Uday Bedi, who is actually a practicing advocate and also a writ petitioner who's challenged the intermediary guidelines, part two of the intermediary guidelines. Why his challenge is important is because it's not a public interest litigation. He's not taken a larger cause. His statement is that his rights are being infringed and therefore he has filed this present writ petition. And I think details of the challenge will be explained by Vasu.
Hi, everybody. So I think Uday's challenge is extremely interesting to all of us because the intermediary guidelines ultimately allow social media companies to take down huge amounts of speech, and that's user speech. So ultimately, our own freedom of expression rights are being infringed by these rules. However, companies like Facebook, Instagram, Twitter may not really be incentivized to challenge these portions of the intermediary guidelines that actually make their lives easier because it allows them to delete vast amounts of speech. So I think ultimately the question is of whether or not the intermediary guidelines infringe our freedom of expression as internet users will more likely be determined in petitions like Uday's than in petitions that are instigated by, say, Facebook or Twitter or Instagram or WhatsApp. And just by way of a quick update, in the episode, we talk about whether or not WhatsApp will challenge the intermediary guidelines. And since recording the episode, they have challenged the intermediary guidelines. However, they've only challenged Rule 4.2 of the guidelines, which regulates whether or not they're required to trace first originators. And I think that's a great example of how social media companies may challenge provisions of the guidelines that make life more difficult for them, but may not necessarily challenge provisions of the guidelines that restrict user speech. And that's why I think Uday's petition is so important.
Everyone, hi Uday, thanks for joining us. I don't know if all our listeners remember that in our last episode when we were discussing intermediary guidelines, we were joined with Mr. Sajan Pavaya, and he had specifically said that these rules, sorry, are a issue not are a issue of individuals' fundamental rights, and this is how we should look at. And individuals should actually come and start challenging these rights. Luckily, we are joined by Uday Bedi, who challenged this in a writ petition in the Delhi High Court. So I think before we start, Uday, we would just like to know that what is this challenge and what made you make this challenge in the Delhi High Court?
Sure. Thank you for having me. So what I have challenged is the two particular rules of the IT rules 2021, rules 3 and rule 4, that are the subject matter of my petition that I have filed before Delhi High Court. And so the rules that have come into force are basically divided into broadly two chapters. One chapter deals with the conduct of the various social media users over platforms like WhatsApp, Instagram, Twitter, etc. Okay, that is the first chapter, which contains the rules 3 and 4, okay, which is what I am challenging. And there's part 2 of the rules, which has got more to do with websites such as the Wire, the Quint, etc. Those websites who publish news. So that part of the rules is concerned only with them, and my petition challenges only part rule 3 and 4. Now, the reason why I went ahead with challenging these rules was it's actually, when we were back in college, we that judgment came out in 2016. I was yet to graduate, the judgment of Shreya Singhal. I'm sure you guys have read that judgment. So when it came out, we actually saw it and read it with so much enthusiasm. We knew that she's a law student, and somebody has challenged something, and it's really interesting to read. So I read it at that time, and it just somehow has always stuck with me as to what happened in that judgment and all of those things. So one key aspect of that judgment was there was a challenge among various other sections. It's usually known for challenging Section 66A on freedom of speech and expression, right? That was struck down in the judgment. There's also another very important factor, which is Section 69, subsection 3. That was also subject of challenge in that particular petition. And What that section allowed was that the language of that section was slightly vague, and it allowed for social media intermediaries such as WhatsApp, Instagram, etc., to take down information in case they felt that something was wrong, or if they received intimation from a court or the government. Okay. So that aspect was challenged, that these powers are too broad. Now what the court held in that instance was that the only case in which that particular section can be considered as constitutional is if we read down this aspect of the section which says that they can do it voluntarily. That if they receive a complaint from a private individual that there is a certain post that offends me or is against the IT Act or the rules, that the private social media intermediary could take it down. That particular aspect was struck down. It was held that it is only if there is a court order or there is an order from the government body to take a particular piece of information down from their server, right? That was the only limited scope till which that section was held to be constitutional. Okay, so that somehow always stuck with me, that okay, fine, these are the powers of the social media intermediaries. And when these rules came out and when I saw them, when I read them in detail, the first time I read them, I didn't really realize, that okay, fine, I thought that they're okay. But then when I properly read them, gave it a very good read, I realized that they have brought back the same powers that had been specifically struck down by the Supreme Court. And that is what prompted me to challenge these rules. That, they have clearly overruled what Shreya Singhal wanted to do.
Right. I think that's super interesting because obviously we have read your petition, and while it's very, very lengthy, one of the key grounds that we definitely focused on was the fact that the rules expressly seek to overrule the judgment in Shreya Singhal. In our last conversation, when we spoke to Mr. Sajjan Puvea, he mentioned that there's sort of three buckets of content that intermediaries deal with on a day-to-day basis. So he talked about content that is immediately on the face of it illegal. So something like child pornography or nudity or something like that. The second bucket he talked about was material that's disputed. So for example, a post that's allegedly defamatory, right? And the third kind of information is information that the government may not want. The government may have an interest in restricting, so say national security. Now, what you just mentioned, Shreya Singhal clearly, I think, most explicitly applies to the second bucket, right? So questions of defamation. So, for example, if I post something that's allegedly defamatory against Rishabh, then, like under Shreya Singhal, the intermediary is not required to take that down merely because Rishabh says it's defamatory, right? But I just wanted your opinion on the other two buckets, right? Because if a court order is always required, then, for example, in cases of expressly nude or expressly offensive material that anybody can see is illegal, right? Do you think that people should still be required to go to a court in those situations? Or would we maybe want to give intermediaries some ability to take down content in those situations?
Yeah, so I have two answers to that. First is actually a rather funny example that deals with your first category of cases of child pornography. So a few days ago, I had met a friend and she told me that over Instagram, she had shared a joke with a friend. There was a photograph, okay, so we, popularly call it as dark humor, right? It was just a small boy and then a small girl on top of him. Okay. There was no other content, there was no attempt to pornography, nothing at all. Okay. That person's account was taken down, all posts were deleted, everything. She lost complete access to her Instagram account. Okay. So essentially, I mean, what we need to understand is as to how much power are we supposed to give to these intermediaries, because what these rules don't provide for is the fact that who is this person who's deciding these things. It is in fact the central reason why, I had a real problem with these rules was that there is no description of who is it who is going to decide whether a particular content is right or not, whether it borderlines on child pornography or whether it is humorous, whether it is detrimental or whether it is not. The rule says somebody senior. I mean, a senior peon could also be somebody who could do it, right? And they don't even require, from my understanding of the rules, they don't even require that person to be in India. Somebody abroad who's not a resident of India is going to decide whether Indian laws are right or not, whether they have been followed or not. Right. So that was my issue. So insofar as I agree that to a certain extent intermediaries should be given that power. In fact, there is a particular rule that talks about immediate taking down of child pornographic material, etc. I have not made that as a challenge in my petition. I have left that out because I thought that perhaps there is some reason to it. Okay, maybe
Mhm.
after deliberation, I may still feel that that is also wrong, but in my petition, I have not focused on that because I
Mhm.
felt that perhaps there may be some merit in that particular rule being there. Although there is slight difficulty there as well, because what the rules say is that that the intermediary is going to employ artificial intelligence to deal with it. Right. So once again, there are both pros and cons. There are cons of having artificial intelligence do this kind of things. It takes away the entire aspect of the gray area, the blurring of lines between white, gray, and black. So that is a problematic issue there as well. And as far as your third condition is concerned, which is on national security, etc. In fact, I have stated so in my petition that look, my objection to these rules can only be to the since I am asking for protection of my freedom of speech, right? Article 19(1)(g), right? Now, Article 19(1)(a), sorry. The restrictions on my right are also there in the Constitution, right? Now, my point is that insofar as these rules are restricted to that end, I can have no issue. But the problem is these rules go beyond those categories which are stated in Article 19(2). And which
Mhm.
is where the challenge kicks in. That unless you amend Article 19(2), include those grounds, you can't have these rules which have conditions over and above what the Constitution allows for.
Yeah, I think I also want to circle back to the example you gave, because that, like, even though that broadens our discussion a bit, I think that's very, very interesting. So if I send you a personal message, and that's a personal conversation, and okay, we agree that that message I've sent is offensive, and that may be in that gray area. But now, what these rules are effectively allowing, do you feel what these rules will allow is that a private chat between two individuals is also being constantly monitored? I know that you've discussed it with
Yeah,
respect to
yeah.
WhatsApp in your this thing in your writ petition. But then this is a very interesting example, because now any action that I take in my private messages, so my private thoughts effectively are being challenged. I think that's a very interesting part.
Exactly. In fact, there are two, clauses in the rules itself, which show that there is constant surveillance of communication. First is with respect to powers of significant social media intermediaries such as WhatsApp. Okay, that's particularly Rule 4. What that allows is for WhatsApp to identify the first originator of a message. Right now, all these WhatsApp, Telegram, etc., they're supposed to be encrypted conversations, right? That's what their privacy policy says, right? Now, what needs to be explained is, and because there is absolute lack of clarity on how it is going to happen, right? The government has no stand on it. WhatsApp clearly says that everything is encrypted. We can't read anything. So, question becomes, how are they going to identify who is the first originator and of what message? If I send something derogatory to you and say you may not send it to Vasudev, right? Now, whether you have further sent it to somebody or whether I in fact received it from you in the first place, right? For that to happen, they'll have to go through every chat of yours. Until and unless they don't see where else that message has been shared, they will not be able to find out who's the first originator. So that was my first cue about, that was the first reason why I thought maybe this is about constant surveillance. That was number one. The second aspect of it, which is that in rule, there is a proviso to rule 3(1)(d). Okay, well, it's the third proviso, I believe, to that rule, which says that there's, they have introduced the word on a voluntary basis. So posts can be taken down if the court orders or there is a order from the government or on a voluntary basis. Now, how is it voluntary basis? Right? What do you mean by voluntary basis? It cannot happen until and unless you're watching what I'm doing. Right? So either they come out and explain what does it mean.
Yeah.
Okay.
So I just have sort of two quick questions. One on the traceability and one on what you just mentioned, which is on a voluntary basis. So just circling back to the petition on traceability, you mentioned that the government doesn't really have a stand on how it's going to operationalize this. And that really seems to be the stalemate, right? WhatsApp says it can't be done without breaking end-to-end encryption, and the government says it potentially can be. So just in terms of, as a lawyer who's actually filed a petition, do you see this as being a sort of potential roadblock in that how does the court adjudicate a question like this, where the government has basically said that we don't know how we're going to do it, but we are going to do it, right? And how does the court sort of deal with that kind of a situation? Do we wait for the government to come up with a way, in which case the petition could be, sitting in court for many years? So I'm just curious about that. The second question I had was on the voluntary basis. One potential way to read a voluntary basis, for example, in my head would be if a user flagged it, right? So I'm a social media company and I don't need to monitor everybody's posts to find out if it's, say, potentially either child pornography or defamatory. It's only when a user flags it, right? It may not be a private notice, right? But it just might be that I report content, like all these social media companies allow me to report content. And then I take up a voluntary call and say, okay, no, this content is wrong. And so I agree completely that this also falls into the problem of the power we give to social media companies. But I'm just wondering if that's one possible understanding of a voluntary basis.
Yeah. So, okay. So to the first question, my response would be that till the time the government doesn't come and answer as to how they're going to go about it, I think if the government takes that stand, that itself is grounds good enough to stay these rules. Because today they have come out with rules which they have no mechanism to implement. Right. And in the absence of that mechanism, which is secure, which is safe, which ensures the rights are protected, the rules must be stayed at that very moment. Because that is the very definition of arbitrary, right? You're doing something, you have passed a law without even realizing that you have no means to implement them, right?
Mm-hmm.
And WhatsApp, to my mind, I don't know how, because their entire campaign is all about privacy. That's what their privacy policy is about. I don't really see how WhatsApp is going to say, okay, fine, we'll open our messages for this jurisdiction precisely. I don't see how WhatsApp is going to respond to that. In fact, there was news that even WhatsApp had challenged the same rules. Although I feel that petition has not yet been, listed before the court. I may be wrong. At least by the time that I had filed, WhatsApp's petition hadn't been listed yet.
Mm-hmm.
Okay. So, but I am assuming that they have also raised a similar challenge by saying that, we will be, I'm completely assuming it right now that WhatsApp will also say that, look, we'll have to open all the chats. There is no other way to do it. And that is, I am also certain that that is a burden that even WhatsApp will not want to take. We are a huge population. They don't want to keep going through all of our conversations the entire time. That's not what their job is. So, yeah, so that is the answer to the first question. The second question, yes, you're right, that a possible way of doing it could be that you flag it. Now, my answer to that is that number one, if that is the case, it should be clarified. That is number one,
Yeah.
because ultimately the rules can't be vague, right?
Mhm.
Number two, once again, going back to the same issue, user flagging it. A user flagging a particular content is exactly what Shreya Singhal set out to, strike down. That a user is not going to decide or tell a private intermediary that, look, I find this objectionable, so you take it down. Right? That is precisely what was struck down. So unless you
Mhm.
change the law, unless you amend section 69 once again, right, which allows for private intermediaries to take down posts, these rules are bad till the time that section is not amended. In fact, there was a judgment also of the Supreme Court in that Jallikattu case. So there's a series of cases with respect to Jallikattu tradition in South India, right? So
Mhm.
in 2014, it was, the practice of Jallikattu was once, abolished, that, it can't be allowed to go on because it leads to animal cruelty, etc. Right. Now, after that, also what they did was, without adhering to what the judgment said, there were fresh notifications that went out, okay, which essentially went back to the same position. Supreme Court has struck them down, saying that, look, you honor what we have said. If we have struck down something, you honor it. Your new rules must remain within the bounds that we have issued already. There are numerous cases like that where Supreme Court has held that, look, you cannot, without amending the law, without making that foundational change in the law, you cannot, by way of a subordinate legislation, do things like this and take away the rights. So therefore, even if on a voluntary basis you're allowing a user to flag an issue, the problem remains the same.
And I think another issue with user flagging, which I was just thinking right now, is that because the first part of these rules is that there might be AI used to adjudicate upon these issues, like not a human person adjudicating upon. And then an AI is basically been trained by user flagging. So effectively, if every user is flagging a post that they find offensive, that can just lead
Yeah,
to like brute majoritarianism of opinion on these websites. I think that's an issue that, so all these issues, when that's the thing, was if not discussed in detail, these issues may seem like a hyperbole. But if you really start
yeah,
looking at these rules and you really start looking at how these rules will actually work, you start realizing that these examples are may not be hyperbole, and they may actually be the case that will happen by the end of it.
yeah,
Yeah,
correct.
and I
That's
think just one more thing on the sort of user flagging. I mean, just pure statistics in terms of what happens with user flagging, the way I understand it is, if I have 500 followers on Instagram, the probability of me getting reported is very minimal. But if I have 25 million followers on Instagram, the chances of me getting reported are extremely high. So
true.
automatically you have that sort of asymmetry where people who are sort of either public figures or who have more followers on social media automatically just get flagged a hell of a lot more. And then there are certain, say, darker corners where there may be more offensive content, but because it's circulated in closed circles, it doesn't get flagged at all. So that's always one problem with that kind of a system.
Yeah, because I think
Correct.
Facebook has that group. It's called it has a dark humor group called the Tomb of Dark Humor. That's effectively just very dark jokes, but nobody's reporting those jokes. So the AI is never figuring out that something wrong is going on. So then you'll allow these pockets within a larger sphere of social media to exist, which is also a problem, I
Correct,
feel.
correct. That's right.
I think another question that I wanted to ask you was that
Mhm.
you've dealt it in between, but I think the aspect is that these rules are actually not in place. So effectively, there is no real right that's being infringed right now, and there is
Mhm.
a threat of infringement. And I think you've discussed it quite a lot in your writ petition. So I think that's the issue, that even if my right is not being infringed, just the passing of law gives me a right to challenge it. I think that's an interesting aspect that we want to discuss.
Yeah, so in fact, when I was, when I was planning to file this petition, one question in my head was, that perhaps there will be an issue of locus, as to why are you coming? It should not look like a PIL, it should look like a writ petition, because I didn't want it to seem like, I'm doing, this for the public and all of that. No, I had an objection with the fact that this potentially infringes my rights. And that is why I thought of, I wanted to see how to show that I do have a locus here. So that is when I did some research on, how to, on what basis can I in fact file a petition under Article 226 and come to court saying that, my rights have been violated. So I came across a number of judgments and I have quoted them in my petition as well. And they talk about the fact that, look, the moment that law is passed, a threat exists, right? And the moment that threat exists, now a person cannot be, expected to wait for a notice to come down his door, knocking on his door, and oh, then I'll rush to the court and try to stop it. That's exactly what they say. In fact, there's some judgments on sales tax issues, etc., where there was no notice issued to a person, no assessment was done, nothing. Simply on the passing of those rules, the court said that no, the point is that there is a threat that a proceeding may take place against you, and that by itself, when that apprehension comes in the mind, and knowing that that apprehension may be arising out of something that is patently arbitrary, that is when the courts are required to step in. So till the time I don't suffer something particularly should not be grounds enough to not entertain a challenge like this. The moment there is a threat, the moment, and it's not like, in fact, I'd say the fact that these rules are in place and they are already in force, right? Now, my challenge also is that, look, they are reading my conversations. Right, that's what they're allowing. So that is happening already. So my right is already infringed the moment it came into play. Right. So I technically don't even need to take that shelter that, perhaps I am going to wait till the day my post is taken down. Right. Essentially, my right is withdrawn the moment there is a surveillance over my communications. So that's what I thought. But I still kept it as a ground just to, buttress that argument that, look, I still have a locus, even though my post has never been taken down.
Yeah. So I guess my question is sort of two-pronged in terms of when you say it's a question of whether or not you as a citizen have the right to challenge the rules. And then in my head, there's a slightly separate question of whether or not you need your right actually to be infringed. I'm just wondering if because in India, at least, the way I understand, say, Article 12 and Article 13, Article 12, which talks about state action and what constitutes state action, and Article 13, which is the prohibition against the violation of fundamental rights. Now, one way that I've seen a couple of Supreme Court judgments deal with this is to say that you don't actually need a citizen's right to be infringed, because Article 13 merely says that the state shall make no law. Right. Correct. So as the constitutional fault is actually with the existence of a law. It's not even with the actual infringement of the right. So then, like you said, you don't need to wait for something to happen, because as soon as the law is passed, there's a constitutional fault with that. So I was wondering if that's something that you would consider also in this debate.
So yes, and I did consider it. I have not, in so many words, dealt with it in terms of Article 13 in my petition, but the way I've dealt with it is to say, what I've said is that, look, when you're talking about protection of fundamental rights, the obligation on the state is two-pronged. There is a negative obligation and then there is a positive obligation, right? Now, a negative obligation is obviously that the state will not create laws that violates fundamental rights, right? Which is the argument that of Article 13, the fact that there is, it's known that the state cannot come up with laws that can violate fundamental rights. So that's where it covers the ground of Article 13, I felt. Or I've gone one step further, and I have sent their judgments to support that ground as well, that even a positive obligation is created and that positive obligation is that you have to create an environment that ensures the protection of fundamental rights. It is not only that you should not violate them, but you should also create that atmosphere which prevents them from happening. Because I'll tell you, one of the issues that a fundamental issue that came in my mind was that it's already the case that these private intermediaries, they take down posts day in day out. That happens, right? So what has changed? That was a question that came to my mind. Nothing has changed. They still have that power. They had that power earlier also. They have that power even now. So why a challenge? What's gone wrong? So my answer to that is clear that earlier it was unregulated. There was nothing in the law that described or prescribed how the intermediaries are supposed to act. Today, when they have been regulated, they have now been given the power specifically to breach our rights. And that I feel violates the positive obligation on the state to ensure an environment that protects my rights rather than infringing them.
I just have one last question on that from my side, which is that so you mentioned, right, that they have been expressly empowered by the intermediary guidelines to voluntarily take down posts, which certainly would infringe the ability of users to post content on the internet. So I guess my last question would be, because it's the government that's regulating these intermediaries and giving them permission to take down posts, how do you see the sort of Article 19 violation? Because Article 19 and all our fundamental rights typically operate vis-a-vis the state. But here it's not the government taking down our posts. Rather, it's the government empowering social media intermediaries to take down our posts. So I'm just wondering how you're bridging that gap.
Yeah. So two arguments again. One is the argument that I just gave you, that there is a corresponding positive obligation, that they ought not to have made a law, right? So that is one aspect of it. And there's a second aspect of it, to which I explained this before also. So my objection in the petition is limited to the fact that your categories of taking down information can only be restricted to the grounds in Article 19.2. Right. Now, what they have done, there are 2-3 clauses in the rules, okay, particularly Rule 3.1D. Okay, what they have done is they have gone beyond that. They have said that, so if you read them, they start to look like everything that Article 19.2 says. Okay, but then there is a further, the last sentence in that rule talks about if there is any violation of any law for the time being in force. Right. So the problem with that is, it is obviously beyond what Article 19.2 says. Okay, there is no such restriction. Secondly, what is to stop the state from creating a law barring certain communications? There's nothing to stop them. So the moment they breach that sort of holy grail of what Article 19.2 is all about, the moment they breach that, I feel that needs to be curtailed. So yes, the private intermediaries, obviously, strictly speaking, no rights are enforceable against them. But the government must put in a mechanism to ensure that they are not given the teeth to, in fact, be able to do it. That is where the crux of the petition lies.
I think an interesting thing to point out to our listeners is that this discussion on you having a locus is very important, because what happens in court hearings usually is that if the judge wants to dismiss your case, he will try finding these technical objections. Like, even though law is in your favor, he'll find these technical objections and raise questions like, what harm is being caused to you right now? What is your locus? Which right is being infringed? But if they want to issue a notice, they'll issue a notice nonetheless. So that's why for our listeners, very important to know that it's very important to write these arguments, because you don't know what the judge will actually do and how he will really perceive your petition. And I think that's interesting. That's why it was very interesting. Like, I have never seen it before in a petition. And I think Vasu and I were discussing it before, that it's a very interesting line of argument to mention in your petition to ensure that there is no such technical objection. And I think I think what we want to ask you is something like, how was it arguing this case, and what do you expect will happen in this case in the future?
So in the first hearing, I was fortunate enough. I mean, the notice was issued right the moment I started, in fact. So that was good. I didn't really have to persuade. Perhaps they had already read my, at least they had read the petition, what I had filed. I'm assuming. So that's why they agreed to issue notice. What I'm expecting now is that the next hearing is on the 13th of September, and the Union of India is supposed to file their counter. On the next date, I am prepared to argue on the stay of these rules. The Bombay High Court has already stayed a different part of these rules. Just a week ago, they have stayed Rule 9, I believe, which deals with the news publications, etc. The other part of the rules. So what I am prepared to argue on the 13th is why these rules need to be stayed now, till the time the government doesn't come out with an explanation of how they are going to monitor these communications and how these rules are actually going to be implemented. So till the time there is no mechanism, it largely remains arbitrary, and that is something we must protect the citizens against.
Just to sorry to cut you, just to tell our listeners, what do you mean by issuing notice? Because I think that's an important step that maybe some people might not know.
Yeah. So issuing notice simply means that the government has accepted that there is some merit in the petition and it deserves to be heard, and the government also is required to respond to the allegations made in the petition. So issuance of notice simply is to ask the government to respond to all that has been raised in the petition.
Yeah. I mean, I don't have too much else. I guess I have one last sort of question about the whole process that you've undergone, because it's very rare that you actually get to talk to a citizen who's challenged the law. And I guess at some level, we're all against arbitrary government power on our couches, but it's very different when you have to raise your voice or put your name on a petition. So I'm just wondering, sir, if you can give us a snapshot of like what your thought process was, because many people, especially lawyers, may not necessarily want to go up against the government. So I'm just curious about that, and I guess we can wrap up on that note.
Yeah. So in fact, when I was actually planning to write a research paper, that's when I was looking for topics to write a research paper on, and this was one of the issues that I thought was perhaps interesting. And so that's when I picked up these rules and actually read them in detail, as to what is the extent of these rules and everything. And I had, in fact, started writing a paper. And just, while writing it, I realized that, when these things are so wrong, in my head, I was like, these things are extremely wrong and something needs to be done about this. So that's when I thought that it may be better to convert this from an academic piece to actually do something that tries to bring about the change. So that was, that simply was the thought process. And yeah, I think no other motivation. I never really thought about, it's really not about going against the government. What those inclinations can be any which ways. My thought wasn't about going against a particular government or anything of that sort. Ultimately, governments will come and go. These rules are going to remain. So my motivation came from the fact that nobody should have such unbridled powers. And ultimately, it's nothing but you affecting my conversations. In fact, I have mentioned it in my petition, it is actually true. Some of my clients are actually hesitant in discussing things. That, what if our conversations are being tapped? Because I deal with a lot of, matters, criminal matters, etc., etc. And they're like, look, we are not comfortable discussing. So that was also something that led me to, immediately challenge it.
I think we wish you best of luck for this petition, and I think that's thank you. We'll closely follow this writ, and we'll hopefully it comes to something fruitful, and
let's hope so. Fingers crossed.
Okay, thank you, Uday. Thank you for joining us.
Thank you guys.
Thanks.
Okay. Bye-bye.
Bye.